before this court, draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. The case in our docket this morning is DeAndrea versus Board of Commissioners of South Walton. We'll hear from the appellant.
Good morning. May it please the court. My name is John Davis, and I represent Gary DeAndrea, the appellant in this case. This case is a case of contract interpretation and construction. What the construction supports in this case, and the construction the court ought to be applying here, is to make sure that the parties' intentions are followed in this case, and they should be determined from reading the contract as a whole. The case ended at the lower court on summary judgment, and again, it is a contract interpretation case, so this court looks at it de novo in that case. And the facts below are undisputed. It's Mr. DeAndrea and the district, the South Walton County Mosquito Control District, entered into a contract where Mr. DeAndrea was the director of their mosquito control. He'd worked under similar contracts since about 1997. And this contract itself actually refers to his previous contracts because it says the salary he'll have in this contract is what his present salary was, working under the other contracts. The district drafted this contract too, which I think is significant in the sense that to the extent there anything that resembles an ambiguity in the contract, then it is construed against the district and in favor of Mr. DeAndrea. The contract provides a term of 2 years and then states in that same paragraph that unless the term will be from October 105 to September 05, unless it is terminated, and I think the term terminated is important here, by either party as provided in the agreement. And then if you look at Section 8 of the agreement, it sets out in great detail, in fact it is the most detailed part of the agreement, the various ways that the contract can be terminated. It can be terminated by Mr. DeAndrea if he gives 30 days notice of termination of the contract. It can be terminated at will by the district, but provided that if the district does that, the district must pay him a severance, and that's what's at issue in this case.
Counsel, if this contract was basically indeterminate, what was the purpose of putting a 2-year time period on the face of the contract? Just looking at the face of the contract.
Well, I think
the purpose in 2 years if it's a matter of continued employment until you go through a 6-month period.
The purpose of that is I don't think a contract would be enforceable otherwise without a term. And I believe that the reason one would put a term in a contract like this is to make it enforceable for the parties. The contract can certainly be terminated, and it sets out the various ways that it can be terminated.
You say a contract that says I'll employ you and pay you a certain amount per month and you start on a certain day is unenforceable because it doesn't have an ending date?
Well, if it's an at-will, if it is a terminable at-will contract, my understanding of the law is
so it says, but and if I terminate you, I'll give you 6 months severance.
Well, in that sense, that might be enforceable. But again, generally a written contract, it's my understanding the law requires that there be a term in it to make it enforceable. If it's otherwise just terminable at will, it might not be an enforceable contract, and I believe that's why such language would be placed in a contract like this, to make it enforceable for the parties.
In what that most people have a contract that's terminable at will. I mean, they don't have a term for 2 years or not for 2 years, and this does have a term. So, yeah. So their position, I understand it, is that the term ended, the contract covered 2 years. At the end of 2 years, they can decide whether to renew the contract or not.
Well, what I think's wrong with their position is the contract nowhere provides for the situation in which it might expire. In fact, it actually has a continuation clause in the contract that states that if the parties, the language of that clause is itself, in my view, somewhat ambiguous and supports Mr. DeAndrea's position. The language in that clause is that if the contract expires without, or should the contract expire, the agreement expire without the parties having entered into a new one, the terms of this agreement will govern the employment relationship. And I believe that that could cover the very situation here, and it also Where they didn't, it's clear that the contract expired before a new one was entered into. The terms of this agreement provide that if you're going to terminate this agreement, as is even provided in the terms section, you have to do it as provided herein. And as provided herein takes you immediately to Section 8 of the contract, which sets out the 4 ways, I guess, in which the contract can end. It can end by a mutual agreement. It can end by Mr. D'Andrea doing it with 30 days' notice, or with the district doing it but paying a severance.
Even your Section 9, continuation of the employment after expiration of the agreement provision, anticipates that the contract expires.
But then it says the contract.
Well, that's like a holdover. That's like if you have a tenancy, then you become a tenancy at will. If this was a lease in an apartment.
I don't see that it was designed for that purpose. I know
why use the word expire if it doesn't expire?
Yeah, but what it's not talking about, it's talking about it if it's expired, then the next language after talking about the expiration. Indeed, that's the only place I would say in the agreement that expiration is mentioned, is that particular place. But then in the next sentence, in the next clause of the sentence, it says if it expires, it will continue to govern unless they've entered into a new one.
Well, that's if they continue to. As I say, it's like not evicting somebody from an apartment. They continue to hold over.
Well, the language, that's one interpretation of that, but the actual language of that provision doesn't say it. It doesn't say, should the term of the agreement expire before the employer have entered into a new one and the employee continues to work after such time, then they'll govern. That's one situation, but that situation is not specifically stated in that. But more to the point, I think, is what the intent of the contract is, and the intent of the contract is borne out by the termination sections, is that Mr. D'Andrea would have some severance if the contract is terminated essentially without notice. And effectively, that's what they did. They've told him, we're not going to continue this contract any further, and we're not going to pay you anymore on such and such a date.
And what was the date? Wasn't it September 2000?
It would be the end of the term. It would be September 30. That's right. And so they're telling him, we're not going to pay you anymore on that date. And this contract and the intent of this contract throughout it is to protect Mr. D'Andrea in the event of a termination. Indeed, there's a corollary to the severance provisions of the agreement, which would be requiring Mr. D'Andrea to give them 30 days' notice if he wanted to terminate the agreement. One thing, as I say, is the agreement is silent on what happens in just the expiration of the agreement. Indeed, taking the defendant's position in this thing, I believe, completely goes against and defeats the intent of this agreement, which was to make sure that Mr. D'Andrea, in the event he was going to be terminated or his employment would be terminated without any notice of any without any notice, is that he would be given a severance. And likewise, I say there was the other thing. He had the option of terminating the agreement too, but he had to give 30 days' notice. So it has a corollary provision in it to protect both sides in the event of a termination like this. And again, to the extent what the court ought to be looking at is the court ought to be looking at what is the intent of the parties and what this agreement is trying to do in the parties and what they're trying to achieve in that. And I believe what they're trying to achieve, and the agreement says it, is that each of these people will be protected in the event of a termination of the agreement like occurred in this case. Furthermore, to the extent there are any ambiguities, those ambiguities are going to be construed against the drafter of the contract. As it stands right now, there's nowhere in the agreement that they provide for anything about the expiration of the agreement. And what really ends up happening is if the employer were to terminate the agreement a minute before it was to expire, they'd have to pay the severance. If they were to terminate the agreement a minute after it expired, they would have to pay the severance. And then they've got essentially a gotcha point in there when they send Mr. D'Andrea onto the street with no severance, which it appears that the agreement was designed to avoid that situation.
So if the commissioners had voted to extend a new contract to Mr. DeAndrea, and they voted, we want to extend it for another 2 years, and Mr. DeAndrea wanted to go work somewhere else, had another job lined up somewhere, is it your position that he would have been required to work 15 days past the end of this contract, or however many days? I guess it was the 17th of September. So would he had to work an additional 2 weeks?
I believe he would have. I believe under the contract he would have had to give him 30 days notice. Now, what their enforcement mechanism for that, I don't know, but I believe under the contract he'd have to give him 30 days notice. The contract doesn't provide what the remedy for the employer might be in that situation. I don't know, but I think the contract says that they would have to give him 30 days notice. I did not say this at the beginning, and it may be too late for me to say it, but may I reserve a few minutes for a rebuttal? Thank you.
May it please the Court. My name is Michelle Buckaloo, and I represent the South Walton Mosquito Control District. First, I'd like to clear up an error on my part. I did not file a notice of appearance in this case prior to arguing today. However, I've spoken with the clerk, and I will file one immediately after I leave here today.
But you're on the brief.
Yes, I signed the brief, but I was under the understanding by the clerk I also needed to file a notice of appearance. So if I need to do that as well, I will do that. This case is about the interpretation of two clauses within the contract. To interpret the contract as Mr. DeAndrea suggests, he would be getting paid for a job he did not perform. If he had continued employment after the expiration of the term of the contract, then we would have a different story here. However, this is not what happened. Mr. DeAndrea was made aware of the fact that the contract was ending at the board meeting, which occurred on September 18th, 2007, when the board voted not to renew the contract. The term of the contract is clear here. It extends from October 1, 2005 through September of 2007, unless the contract is terminated by either party. And I believe Mr. DeAndrea is ignoring the term unless in the term section of the contract. Here the board voted not to renew the contract before the term expired. So we're not dealing with a case of termination. We're dealing with a case of non-renewal of a contract. The term wasn't given just as an afterthought. The term was obviously an intention by the parties to have a direct end date to the contract. After September 30th, 2007, Mr. DeAndrea was no longer employed by the district. He did not perform any services, and he was no longer paid.
Well, the district bargained for a situation in which they decided they no longer need Mr. DeAndrea's services, but they're going to pay him for 6 months anyways while he's doing something else, even if he got another job, even if he's able to mitigate his damages. So they contemplated paying him for 6 months for doing nothing. How are we supposed to look at this and say, but it's okay to fire him with 2 weeks' notice because of the timing of it?
Because I think the distinction here is the use of the word termination. He was not terminated under this contract. Instead, the contract was not renewed because the contract envisions a specific end date to the term of the contract. And what the district did was just decide not to renew his employment after that date. So if he was terminated before September 30th, 2007, we'd have a different situation, and we would look to Section 8 of the contract as to what he's entitled to. However, he was not terminated. The contract just expired.
So would there have been a different result if the board, if the commissioners' meeting was on October 5th?
Yes, because then we would look to Section 9 of the contract, which envisions a situation where an employee continues employment after the expiration date of the contract. And then we would probably need to look at the terms of the contract as to what would happen during a termination. But again, here that did not happen. Mr. DeAndrea had been entering into similar contracts with the district since 1997. These contracts were renewed approximately every 2 years. The language of the contracts were similar. If either of the parties had intended for Mr. DeAndrea to receive severance pay after the expiration of the contract, that would have clearly been written into the contract. And because it was not, that was clearly not the intent of either Mr. DeAndrea or the district. The language of Section 9 on its face is unambiguous and does not support Mr. DeAndrea's interpretation. It only covers circumstances where the term of the contract expires, yet employment continues, which we do not have here. Courts are required to read provisions of a contract harmoniously, and the district believes that a harmonious reading of Section 2 and Section 9 obviously shows that, again, he is not entitled to severance pay when the term of the contract has expired. The argument presented in this case by the district is similar to that presented in the case of Paladine versus Weindruck. In that case, an employee sued for breach of an employment contract. The court found that the non-renewal section of the contract and the termination section of the contract were not synonymous. The court reasoned that if the parties had intended severance to be a consequence of non-renewal, then they could have agreed to do so within the contract. And as I've stated earlier, the district did not intend that, and the district did not intend severance pay after the expiration, or they would have placed it in the contract. Mr. DeAndrea earlier represented to the court that the district drafted the contract. However, there's nothing on record stating that the district was actually the drafter of the contract. The attorney for the district, unfortunately, is no longer with us. He passed away, and so we actually have not, the district has not had a chance to determine who drafted the contract. But again, there's no ambiguity, so that is irrelevant in our situation, because the district would say we'd only need to look to who drafted the contract if the contract terms were ambiguous, and here there's no ambiguity. Because the language of the contract is clear and unambiguous, no issue of law exists, and the district requests that summary judgment be affirmed in its favor. Unless the court has any additional questions, that will conclude my argument. Thank you.
Thank you, Your Honor. As regards being terminated, I don't see what happened to Mr. DeAndrea as anything but being terminated. I guess you could have the situation that if the employer said, if the district had said on September 15 or whenever it was, Mr. DeAndrea, we don't need your services anymore, you'll leave on the 29th.
Mr. Davis, I want to go back to the second paragraph of this agreement says term.
Yes, sir.
It gives a finite term.
Mm-hmm.
Then it says unless. Now, how do you reconcile this with your argument that the termination provisions of paragraph 8 somehow govern the term of the contract? It appears that it has a finite term unless something else occurs that's terminated for a provision under paragraph 8.
Mm-hmm. That unless somebody takes an action to terminate it under paragraph 8.
So it just stops at the end of 2 years. How in the world do you implicate the provisions of paragraph 8 in the original term of this contract?
Well, I think when you read those consistently with the continuation provisions of paragraph 9, and the fact that there's nothing in this agreement which talks about, for instance, this is not a situation like this Paladine case where they have these a non-renewal provision in it which sets a particular point in time at which the parties will determine whether it's not renewed. And in that particular case, for instance, the employer actually gave the notice of non-renewal in that case, and that's a totally different case than this one. But I see this agreement as saying that the language of the thing is that if you don't enter into a new one, these will continue to govern the contract. And that's what's happened here. He's effectively been told he's been terminated. It just so happened they're going to terminate him on the day that the term ends. My point would be if they decided they were going to terminate him a day before, they would have to pay him the severance. Whereas terminating him a day later, they don't have to pay the severance in their view. My hypothetical would be, say 2 weeks beforehand, they said, we're not going to employ you anymore, and your last day of employment will be September 29. They have to pay him the severance in that situation. They say instead, we're not going to employ you anymore, and we're going to terminate you effectively on September 30th, which is the end of the term of this agreement. And their position is we pay no severance in that
What
situation.
if they're just going to say, we're not going to extend your contract, period? It ends when it ends.
Well, it seems to me that when you look at the intent of this agreement, and the intent of this agreement was to protect Mr. DeAndrea in the situation where he loses his employment without notice or anything like that. That's exactly what happened
2
here.
years and gets a 6-month severance.
The notice is a contract. The contract says 2 years.
Well, I do not believe that comports with the intent of the agreement.
Is this the same kind of contract he's been entering into since
They were very similar.
1997?
They were very similar.
And what do they do? Every 2 years?
Well, they had been renegotiated.
Every 2 years?
They had been renegotiated each
Two-year term
time.
contract.
That's my understanding. That's all I have.
Thank you very much. That concludes our case this morning. We'll be in recess.